This video is intended to give a brief overview of your legal options. However, nothing contained herein shall be considered legal advice. This video doesn't cover all the issues you might encounter or discuss any particular issue in depth. Before proceeding with any legal decision, the best practice is to review your particular case with a knowledgeable attorney. Nothing in this video creates an attorney-client relationship. Bankruptcy procedures. After filing bankruptcy paperwork, the vast majority of bankruptcy cases proceed through the process without a hitch. Here's what you can expect. The bankruptcy court notifies creditors of the automatic stay order, prohibiting most collection activities, assigns filing and hearing dates, and appoints a bankruptcy trustee to oversee the case. Your first job will be to provide the trustee with financial or 521 documents such as tax returns, proof of earnings, and banking and retirement account statements. Then you'll attend a hearing called the 341 Meeting of Creditors, where you'll show the trustee identification and answer questions under oath. Most hearings take about 10 minutes to complete, and creditors rarely appear. Chapter 7 filers will have one more thing to do before receiving a discharge: complete the debtor management course and file the certificate with the court. Chapter 13 bankruptcy filers may have to attend a Chapter 13 plan confirmation hearing, where a judge determines whether the repayment plan satisfies requirements and complete the approved payment plan. Motions, adversary proceedings, bankruptcy trials, and other types of litigation don't arise much in Chapter 7, they're more common in Chapter 13 matters. Even so, you can rest assured knowing that most bankruptcy lawyers can identify issues in advance, and will have already formulated a strategy. Do I have to go to court if I file for bankruptcy? You'll need to attend a hearing or two when you file for bankruptcy. For instance, in both Chapter 7 or Chapter 13 bankruptcy, the court will appoint a trustee to conduct a hearing that all filers must attend, the 341 Meeting of Creditors. If you file for Chapter 13, you or your attorney may also have to appear at a confirmation hearing. Depending on your case, you might be required to go to more hearings. Bankruptcy court and trustee responsibilities. In a Chapter 7 bankruptcy filing, the bankruptcy trustee must sell your non-exempt property, assets that you can't protect with a bankruptcy exemption, and distribute the proceeds to creditors. In Chapter 13, the trustee doesn't sell your non-exempt assets. Instead, you pay the value of non-exempt assets through your repayment plan. The trustee will review your plan, however, to make sure it's feasible and that it treats all creditors fairly. If the court approves the plan, the trustee will disperse the monthly payments to creditors. Bankruptcy court and the 341 Meeting of Creditors. In both bankruptcy chapters, the trustee appointed to your case will review your paperwork and supporting documentation, such as pay stubs and tax returns. The trustee is responsible for ensuring the accuracy of your petition and presiding over the meeting of creditors. When you file your case, the court will notify you and your creditors of the time and location of the 341 hearing. While the hearing might be held at the bankruptcy court, the trustee normally won't hold it in a courtroom. Instead, the trustee will oversee the hearing in a conference room. At the meeting of creditors, the trustee will verify your identity and ask you questions under oath about the contents of your bankruptcy papers. Creditors will have a chance to ask questions about your financial affairs as well, but rarely attend the meeting. If you don't appear, the trustee can move to dismiss your bankruptcy, and you won't receive a discharge, the order that wipes out qualifying debt. Bankruptcy court and the Chapter 13 confirmation hearing. If you file for Chapter 13, you or your attorney may have to appear at the repayment plan confirmation hearing. Before the hearing, you'll send your proposed repayment plan to the Chapter 13 trustee and creditors. Each will have an opportunity to file a written objection. If you resolve the issue raised, the trustee or creditor will likely withdraw the objection. If not, you'll have the opportunity to respond in writing and to advocate your position to the judge at the hearing. Unlike the 341 Meeting of Creditors, the judge will hold the confirmation hearing in a courtroom. The judge will consider any objections and oral argument at the confirmation hearing. If the repayment plan is approved, you'll move forward with Chapter 13. If it isn't, the judge will give you time to remedy the problem in all likelihood. If you're unable to present a confirmable plan after a few tries, the judge will dismiss your case. Additional bankruptcy court hearings. Here are other hearings that occur in both Chapter 7 and 13 with some degree of frequency. Motion for relief from stay hearing in bankruptcy court. If you have a car loan or mortgage, and you want to keep the house, car, or other collateral, you must make the monthly payments during bankruptcy. If you don't, your lender can file a motion for relief from the automatic stay, and ask for court permission to foreclose or repossess your property. For instance, it isn't uncommon for a debtor to file for Chapter 7 or 13 to stop a foreclosure or repossession. A lender who stands to lose money as a result of the automatic stay can file a motion asking the court to lift the automatic stay. You'll have the right to oppose the motion and ask the court to hold a hearing. If the Chapter 7 trustee requires the property for the bankruptcy case, the trustee will oppose the motion as well. At the hearing, which will be held in a courtroom in front of a bankruptcy judge, the Chapter 7 trustee will explain that creditors will benefit from the liquidation of the property. The lender holding a lien will be paid in full once the property gets sold, thereby saving the lender the time and effort of foreclosure or repossession. If a Chapter 7 trustee doesn't intend to sell the property, to defeat the motion, you'll need to show that enough equity exists to protect the lender from financial harm, often referred to as an equity cushion, or you can afford the monthly payments and to catch up on any missed payments. If you're in Chapter 13, you'll have to make adequate protection payments before your plan is confirmed. You also must make your monthly payment and be able to catch up on arrearages through your Chapter 13 plan. Otherwise, you won't survive the motion. Chapter 7 Reaffirmation Hearing in Bankruptcy Court. If you file for Chapter 7 bankruptcy and have a secured debt such as a car loan, you may need to reaffirm that debt if you want to keep the car. When you reaffirm a debt, you sign a new contract with the lender that makes you personally liable on the obligation despite your bankruptcy discharge. If your monthly budget shows that you can't afford to make the monthly payments, a presumption of undue hardship arises. You'll be required to attend a reaffirmation hearing in a courtroom in front of the judge. At the hearing, you'll have to explain why you need the car, or any other asset you are trying to keep, and how you can afford it. The judge will decide whether to approve the reaffirmation after hearing your explanation and reviewing your finances. Trustee's motion to dismiss hearing. The motion to dismiss arises in several situations. For instance, if you fail to make your Chapter 13 plan payments, the trustee will file a motion to dismiss your case. If you don't file a document or a certificate of completion for a required bankruptcy course, or if you don't show up for the 341 hearing, the trustee will likely request a dismissal. Adversary proceedings in bankruptcy court. An adversary proceeding isn't a hearing. It's a lawsuit filed in your bankruptcy case that a judge will conduct in a bankruptcy courtroom. If you incur debts shortly before filing for bankruptcy, hide assets, lie on your bankruptcy papers, commit fraud, or otherwise abuse the bankruptcy system, the trustee or your creditors can file a complaint and start an adversary proceeding in your case. Once the plaintiff files a complaint, you will have a certain amount of time to answer or oppose it. The court will set a discovery schedule to allow each side to collect evidence. Each party will present the case at trial. The most common types of adversary proceedings include actions by the trustee to recover fraudulent or preferential transfers, complaints by creditors to have their debts declared non-dischargeable because of fraud, objections to your entire discharge filed by the trustee or creditors as a result of bankruptcy fraud, and complaints to strip junior liens from a house. Only certain bankruptcy jurisdictions require an adversary proceeding to strip junior liens, others require a motion. What happens when the court dismisses a bankruptcy case without prejudice? Filing for bankruptcy relief doesn't guarantee a discharge, the order that wipes out qualifying debt. If you don't follow the bankruptcy laws or procedures in your jurisdiction, the court might dismiss your case. Luckily, most dismissals are without prejudice, and you can immediately refile your case. Understanding dismissals with and without prejudice. When the court dismisses a case without prejudice, you can file another bankruptcy matter right away instead of being required to wait. You can also discharge all qualifying debts in the next case. This type of dismissal usually occurs because of a procedural mistake, such as a failure to file the correct forms, not as a result of unethical behavior. By contrast, a dismissal with prejudice will prevent you from filing another bankruptcy for a specific period, or forever prohibit you from discharging any of the debts existing at the time of your first filing. The court will dismiss a case with prejudice if you try to take advantage of bankruptcy by hiding assets, use the automatic stay to buy time without intending to complete bankruptcy, or abuse the bankruptcy system in some other way. Common reasons for a dismissal without prejudice. After filing your case, you must comply with the bankruptcy rules and procedures. The court dismisses most matters because of the failure of debtors to file the correct forms with the court, submit supporting documentation to the bankruptcy trustee, attend the meeting of creditors, complete a debtor education, financial management course, make timely planned payments in a Chapter 13 case, or fail to meet any other deadlines or requirements. Bankruptcy dismissal and the automatic stay. In bankruptcy, the automatic stay protects the filer from almost all creditor collection activities. It stops them in their tracks. In most cases, the stay remains in place throughout the bankruptcy matter. However, if the court dismisses your case, your creditors can come after you to collect their debts once again. Mostly, you're in the same position you were in before filing. Also, immediately filing another bankruptcy will limit your automatic stay in the new case. Here's how. If you refile your case within 1 year after dismissal, the automatic stay may be limited to 30 days. If you had 2 or more bankruptcies dismissed within the year before you filed the most recent case, the automatic stay may not be in effect at all. In either situation, you can file a motion to extend or impose the automatic stay in your new bankruptcy. You'll need to be prepared to explain to the court the need for multiple cases. Consult with a bankruptcy lawyer. If the court dismissed your case without prejudice, it's reasonably clear that you ran into a problem in the previous matter. A bankruptcy attorney can help you fix the issue, as well as file a motion, asking the court to grant or extend the automatic stay's protection against creditors. What happens if the court dismisses your bankruptcy with prejudice? A dismissal with prejudice can bar you from refiling your case or discharging your debts. If you file for bankruptcy, to try to get over on a creditor, or otherwise abuse the bankruptcy system, the court could dismiss your case with prejudice. Depending on the judge's order, a dismissal with prejudice can prevent you from filing another bankruptcy for a specified period, or forever prohibit you from discharging any debts included in the dismissed case. What happens when the court dismisses your case with prejudice? A dismissal with prejudice will restrict your ability to file another bankruptcy for a period of time. It could also prohibit you from discharging any debts that could have been wiped out in the dismissed case. For instance, a debtor cannot file another bankruptcy within 180 days of a prior case if the court dismissed the case because of the debtor's willful failure to follow court orders, or the debtor voluntarily requested dismissal of the case after the filing of a motion for relief from the automatic stay. Dismissing a case after a creditor asks the court to lift the automatic stay suggests that you didn't intend to discharge debt but instead filed to stop a foreclosure or repossession. The dismissal in that instance is an abuse of the bankruptcy process. The court can also dismiss your bankruptcy for other egregious reasons like committing bankruptcy fraud, and filing multiple cases in bad faith to delay creditors. Bankruptcy judges have broad discretion to dismiss a bankruptcy with prejudice for any valid reason, or for cause. For instance, if you file for bankruptcy intending to hide assets, delay creditors, or otherwise abuse the bankruptcy system, the judge can preclude you from filing another bankruptcy for longer than 180 days. The judge can also forever bar you from discharging any debts that were dischargeable in the dismissed case. The harshness will depend on the egregiousness of the acts. Options after a dismissal with prejudice. If the court dismissed your case with prejudice for a short period, such as 180 days, you could file again after the deadline passes. If the judge ordered a more extended bar, or prohibited you from discharging debts that could have been wiped out, you can appeal the decision to a higher court. But keep in mind that appeals can be costly, and to succeed, you must prove that the judge made a legal error. Consult with a bankruptcy attorney. A dismissal with prejudice is a serious matter, and filing a motion to extend or put in place an automatic stay can be complicated. It's a good idea to consult with a bankruptcy lawyer before submitting the case again. Thanks for watching. Please leave a comment if you want to see more videos like this.